Thank you very much. It's a pleasure to be here with you today. Sanctuary cities. The phrase is made to make you think of state officials standing between the immigration authorities and immigrants who are subject to removal, somehow shielding them from removal and in spite of their unlawful status. But in over 300 jurisdictions, there is no policy that instructs officers to actively thwart the enforcement of immigration law. What we're talking about then is policies that instruct state officials to stand aside from the federal agencies that are responsible for enforcing immigration laws, to let federal law enforcement do their job of enforcing federal laws, while the state's law enforcement resources remain focused on enforcing laws in their communities and keeping their communities safe. So the question before us today is not whether or not state and local law enforcement is allowed to assist with immigration law enforcement. Clearly, they are, if they wish to be so. The question is whether state and local law enforcement can be compelled to provide assistance in federal law enforcement matters, in a civil immigration law enforcement. So in my remarks today, I'd like to briefly address how this current question of immigration enforcement relates to past disputes between states and the federal government over how much the states are supposed to be involved with enforcement of a federal civil law. So you have to go back all the way into the founding of the Republic when you find out that one of the first arguments between the states and the federal government was how much states in the North had to cooperate with states in the South who were trying to return fugitive slaves. And when African Americans would be kidnapped out of New York or Massachusetts or other states, what assistance did those states' legal systems have to provide to Southern agents who were coming up to capture individuals and take them back? And so that was the first set of issues that the Supreme Court had to decide. And in fact, the state of Pennsylvania was involved in a case where it said that the state of Pennsylvania could not make it illegal for federal agents to be able to work under the Fugitive Slave Acts in the state of Pennsylvania because of the supremacy of federal law. But at the same time, they never had to make their own state law enforcement resources available to help with that. Fast forward to Prohibition. Everybody remembers that the 18th Amendment to the Constitution made it illegal to manufacture, distribute, sell alcohol in the United States. But the federal government didn't have anywhere near enough law enforcement resources to enforce that throughout the United States. So states and cities were passing laws that allowed them to also concurrently enforce the 18th Amendment. But cities and states also decided not to. The entire state of Maryland, for the entire duration of Prohibition, never passed a law allowing the enforcement of that. And so, of course, alcohol remained available on a much greater basis in the state of Maryland than in other places. The city of New York had more places where you could get alcohol during probation than it had before probation, again, because city and local officials did not support the federal law and did not cooperate. And the federal government was not able to compel them to do that. When we talk about whether the federal government should be allowed to compel a state or a city to go along with its priorities, I think we need to be careful to think that any precedent that's set in the area of immigration law could be equally applied in other areas of law. So, for example, the Federal Firearms Act requires the registration of certain kinds of firearms, sawed-off shotguns, for example, that may be perfectly legal to possess under state law. But many of those weapons which are involved in terrible crimes are not registered properly under the federal regulations. So should there be a law that says no state shall get federal funding if they refuse to turn over to the alcohol, tobacco, and firearms any unregistered federal weapon that their police encounter? Well, it's not very dissimilar from what happened in the Brady Act in 1993 when Congress said that because there wasn't a national background checking system, state law enforcement officials had to run a background check of any handgun purchaser. All the way to the Supreme Court in the Prince versus United States case, the Supreme Court said the federal government could not commandeer those local resources to enforce a federal purpose. And so that's an important precedent about, federal law enforcement is responsible for the enforcement of the immigration laws. If an individual comes into the United States and they do not have a proper status, if they have a proper status and they let it lapse or they commit a certain list of crimes, they are removable from the United States and the federal authorities are responsible for removing them. But to say that a federal law and a state law enforcement officer has to hold on to that individual while a federal officer is coming to get them, while a federal officer is determining whether or not the person is subject to removal, raises serious constitutional concerns. Because while it is true that it may be a relatively short period of time, it may be 48 hours or less. In some cases, it's not. And more importantly, the Supreme Court has already said it, that the de minimis requirement of running a background check on a handgun purchaser is not something the federal government can compel the states to do. So to require them to hold and house and feed and transport someone who is a person, this isn't just a background check, this is keeping physical control of a person for a period of time, goes well beyond what the Supreme Court has already said is not something that's allowed to be required by the federal government. So then we get to the question of funding for, removing funding as a sanction for refusing to cooperate and provide assistance to the federal government in this matter. Well, the Supreme Court has already made that decision as well, quite recently in the case of Obamacare, where Justice Roberts said that it was unlawful for the federal Obamacare statute to threaten to remove Medicare payments unless states adopted Obamacare's Medicare expansion. So in the same way, if a federal act were to say that states would be deprived of more than the directly relevant law enforcement grants, all right? The grants, for example, that provide states assistance for the costs of housing persons who are undocumented who commit crimes. To go beyond that, to threaten federal funding more broadly, would be, again, an unlawful coercion, a violation of the 10th Amendment. Why are we here? We are here at least in part because we have allowed immigration to be different from every other kind of law enforcement. The city of Philadelphia, where I'm from, has a policy that has been labeled a sanctuary policy. Our mayor has been quite clear that every other law enforcement agency that wants to take custody of someone in the Philadelphia jail system can get a judicial warrant and produce that warrant. The Montgomery County Police can do it. The other federal law enforcement officials can do it. But ICE believes it does not have to. They believe that they can rely on something called an administrative warrant, which is not a warrant at all. The Fourth Amendment to the Constitution says that if someone is to be taken into custody, it must be done upon a warrant proven by probable cause to an independent magistrate. None of those elements are necessarily required of an immigration detainer. In an immigration detainer, our immigration officers will look in a database or will decide that someone is potentially subject to removal. Maybe not even that there's probable cause that they're subject to removal. They will then ask for the person to be detained. If the person is detained with one, so it's a warrantless arrest, similar to when a police officer encounters someone driving around, right? They have to have a probable cause that a crime is being committed. But this isn't even a crime. This is a civil violation of the immigration laws. And so requiring these procedural protections is not about protecting criminals. Requiring these procedural protections is about protecting lawful residents and American citizens. Because situations like in my own state of Pennsylvania, when the Lackawanna County Sheriff's Department was served with an immigration detainer for a US citizen, who was then kept in detention for longer than 48 hours are cases of why these procedural protections are necessary. Why is it not required that ICE bring a person before a neutral magistrate within a reasonable period of time, 48 hours according to the Supreme Court? Why is that such a big requirement that the Immigration Service can't meet, but every other law enforcement agency in the United States somehow manages to? So I want to conclude with a story about community trust, because what our members tell us is that these kinds of issues are fundamental to the relationships that police in their communities are trying to set up with their broader communities of legal immigrants. And there may be undocumented immigrants who live within these communities of recent immigrants to the United States. But the community policing efforts are about establishing relationships. And as a practical matter, what happens when local police become enmeshed in the enforcement of immigration laws are cases like what one of our members reported from Washington State. Now, Mirabella, who is not her actual name, she was arrested during a domestic violence incident. She was the victim of domestic violence by her US citizen husband. She had never called the police before because, of course, her husband was telling her that the police would be on his side and she would be deported. When the police came to the house because of this incident, she only speaks Spanish, and her husband was able to convince the police officers that she had been the aggressor. And so she was arrested. She was taken into removal. She had no relief from removal. She was deported from the United States. So this is a situation where an individual who was the subject of a criminal investigation at a local level became enmeshed in this deportation system. And this is what will happen. If you have a car which gets pulled over that has 4 people in it, it won't matter that there was only probable cause to stop the car because of what the driver was doing. Everyone in the car may become subject to immigration enforcement. And so these are the reasons why we say that each community needs to be able to make its own decisions in these matters. There are communities who will decide to fully participate and cooperate with immigration enforcement. There are communities who will decide to partially do so. And there are communities who will decide to honor federal requests, to comply with federal law that is consistent with the Constitution, but to go no further. And so that's what we're asking should be able to continue.